Mr. Chairman, Madam Chairwoman, members of the committee, thank you for the opportunity to testify today. My name is Kerry Silverman. I'm a lawyer in D.C. I'm here today on behalf of the American Tort Reform Association. I don't represent the church. I represent a group that is associated with businesses, with nonprofit groups, with municipalities that have concerns with the bill before you. I've been here. I've listened to all of the testimony today, every minute of it. It's harrowing, it's disturbing, it's compelling, and it certainly demands consideration of extending the statute of limitations for these types of claims. The concern that my group, the American Tort Reform Association, has is with one provision of the bill, and that's the retroactive 3-year window that opens up claims going back as far back as it possibly could for negligence claims against organizations, private and public. And the reason for that is the type of precedent that it sets for other types of claims, not child sexual abuse claims. Every type of civil claim has a finite statute of limitations, and tort law deals with, and I see it in my practice, which is product liability law, it's personal injury law, it's consumer law, and we see types of cases, wrongful death cases where people have been killed by careless, reckless, or even intentional conduct. People who are at work are maimed by faulty equipment. People who develop cancer or terminal diseases as a result of exposure to toxic substances. People who have birth defects due to prescription drugs that are problematic, medical devices that have complications, medical malpractice claims where people are harmed. In all of these cases, we have finite, limited statutes of limitations, and whenever a statute of limitations is applied, it seems arbitrary, and it is arbitrary. It seems unfair to the victim because what would otherwise be a claim that has merit is not allowed to go in court. But we still have these statutes of limitations because they do serve a purpose. And the purpose of them, which is just critical to any type of civil claim, not just child sexual abuse claims, but the purpose of them is that the courts, that juries can make decisions based on the best evidence possible, that they make the decisions when the witnesses are there, when the witnesses are alive, when there's documents that can be found, when the documents have been saved, when people's memories are fresh. And so the court can make decisions based on the best evidence that's available to determine a claim and who's responsible for something. And that's why we have statute of limitations. And there's no magic number to them. Should it be 7 years? Should it be 35 years? That's a decision for you to make. It's a public policy determination, and it has to provide enough time for victims to bring claims, and it has to provide enough time for defendants to fairly defend themselves in court, and for the court to make the right types of decisions. I'm not going to tell you whether that should be 35 years or something else for these types of claims. But when that decision is made as to what a statute of limitations ought to be, it's usually made prospectively. It's made going forward. It isn't made retroactively. It isn't completely discarded and allowed claims to come no matter how far back, because if that's the way that statute of limitations ought to work going forward, then statute of limitations will serve no purpose and there'll be no predictability in the law for any type of claim. And that's why most states, when dealing with this issue, have not gone the retroactive route. 40+ states have significantly expanded their statutes of limitations for child sexual abuse, as they should. But only about 11 of those states have done so retroactively, whether it's through a reviver window of 1 to 3 years or 90 days, as you've heard in Michigan, or whether it's through a retroactive application of an extended statute of limitations. And they've done that, taken that approach, and not the retroactive approach, I think, for 2 reasons. The first are the policy reasons that I spoke about. The second is because in many states, and Rhode Island, I would group as included in this, courts have ruled that retroactively changing statutes of limitations is unconstitutional. And they rule that way in a way that favors both plaintiffs and defendants. It says that under due process, if a legislature is to say take away or lessen a statute of limitations for a plaintiff, you can't take away their right to sue retroactively. Once they have a claim, they have to have the opportunity to bring it. You can't say, have a statute of limitations that's 7 years, and then when a person is 5 years out, say we're going to change it to 3 years and you've lost your claim. And those courts say that the same principle applies with defendants and statutes of limitations too. Once the time period has run for a statute of limitations, reviving that time-barred claim violates due process. And in Rhode Island, you have law that says that, as you do in the majority of states. So those are the two reasons why states have generally stayed away from this and instead gone to significantly expanding statutes of limitations prospectively. It's hard to be on the side here of expressing concerns. I have tremendous respect for everyone that has testified today and for you in looking at this issue. ATRA's position and has been asked for me to convey today is to look at this prospectively rather than retroactively. Thank you.
Thank you.